Between all of them, they have about 100 firearms. And the state says, you've already got your guns. You don't need a new one. And as a result, you are not suffering irreparable harms.
News of the day. Personal security and gun rights as a whole are changing. The number of firearms that you may own can now be limited by states. Are you prepared to explore this compelling paradigm shift that may alter how we perceive the Second Amendment? Nearly 40,000 Americans died from gun-related injuries in 2017, more than any other year on record. There is a widespread consensus in the United States that policies should be designed to reduce those deaths. But there is still disagreement about which laws would accomplish that. Researchers evaluated 3 common gun laws that regulate how people use, carry, and store their firearms, estimating the effects these policies have on gun deaths. Their findings suggest that states that put the most restrictive combination of these 3 policies into effect could see a small but meaningful reduction in firearm deaths. A law that can restrict gun storage is likely to reduce deaths. States that currently have these laws could reduce gun deaths by replacing these laws with tighter restrictions on who can carry a concealed weapon and/or when they can use deadly force. While there is some uncertainty in the researchers' estimates, they concluded that there is a 97% chance that restricting firearm storage at home is associated with a subsequent reduction in firearm deaths. Certainty is lower for associations between lower firearm deaths and restrictions on the right to carry outside the home is 87% and defensive gun use is 77%. But the main question is, what is the California handgun roster, and how big is it really? And how will this control on firearm ownership shape the future of law and order? The roster of handguns certified for sale is a list of handguns on the California Department of Justice's website that can be manufactured in California, imported, sold, purchased, lent, etc. In other words, the DOJ largely controls what handguns are legally obtainable. Officially, the government says it is not restricting a person's ability to purchase a handgun because there are hundreds of such models on its roster. Even a cursory examination of the roster shows many of these handguns are actually duplicate.
Now, while this is specific to California, this video is actually being done because the pleadings that the state attorney general has put forth in this case.
About 1/3 of the roster's total listings are comprised of makes and models that do not offer consumers substantive and material choices in the physical attributes, function, or performance of a handgun relative to another listing of base models. A federal judge in San Diego has placed an injunction on California's Unsafe Handgun Act as part of the ongoing Rena v. Bonta case, which challenges the state's stringent laws governing handgun ownership. Judge Dana Sabra's April 6th ruling blocks 4 provisions of the law on the grounds that it violates the Second Amendment, which means the California-approved handgun list may someday be history. The Bruin decision says there is no justification for laws restricting the public carry of weapons that are unquestionably in common use today. Every law that is passed must align with the Constitution as it was written at the nation's founding and expanded following the Civil War. Steadily expanded as the list of handguns certified for sale in California dwindles. The counter-argument from the state is that the California-approved handgun list is on a solid legal footing. After all, certain firearms cannot be in common use if they're banned, and they can be banned if they're not in common use. The injunction is good news for California's gun owners and the Firearms Policy Coalition, the Pro-2A nonprofit organization behind the lawsuit. The Second Amendment has been a hot topic in recent court cases, partly because of the U.S. Supreme Court's Bruin decision, which ruled that New York had overreached in its efforts to restrict concealed carry permits. Individuals and advocacy groups are responding by challenging other state laws that they believe violate the Second Amendment. And Rena v. Bonta is a step in the right direction for residents of California.
In 2014, there have been no new firearms, with a couple of minor exceptions. There have been no new firearms added to the California roster of safe handguns.
In 2007, California became the first jurisdiction in the nation to enact legislation requiring firearm manufacturers to incorporate crime-solving microstamping technology in at least some firearms. Microstamping technology causes a firearm to etch a unique microscopic code onto ammunition cartridge cases when the gun is fired that identifies the firearm's make, model, and serial number. This technology could enable law enforcement to match cartridges found at crime scenes directly to the gun that fired them, similar to the way an automobile's license plate may be used to identify a vehicle's make, model, VIN, and registered owner. Signed by then-Governor Schwarzenegger, California's Crime Gun Identification Act of 2007 requires all newly developed models of semi-automatic pistols sold by licensed dealers in the state to be designed and equipped with microstamping technology.
And challenged this roster, claiming that it violated the constitutional test as established in New York State Rifle and Pistol Association v. Bruin.
According to the Crime Gun Identification Act, this requirement would take effect as soon as the California Department of Justice confirmed that several gun manufacturers could use microstamping technology without being constrained by any patent constraints. In May 2013, the DOJ gave that certification. The gun industry, however, has defied this legislation by refusing to release new semi-automatic pistol models for sale in California, since this requirement only applies to new semi-automatic handgun models. Instead, the industry has continued to market new versions of older semi-automatic pistol models without contemporary safety features while attempting to undermine the state's public safety regulations through litigation in state and federal courts. Previously, California generally required newly developed semi-automatic pistols models to incorporate a microstamping mechanism in at least 2 places on the interior of the firearm.
This roster, claiming that it violated the constitutional test as established in New York State Rifle and Pistol Association v. Bruin. They also asked that a preliminary injunction be issued.
In 2020, California passed new legislation to address industry obstruction and ensure more handguns certified for sale and manufacture in the state come equipped with basic life-saving consumer safety features, as well as a microstamping mechanism. This legislation now requires the California DOJ to delete 3 older, less secure, semi-automatic pistol models from its list of firearms that are authorized for sale in California for each new certified microstamping model after it took effect on July 1, 2022. This new law was intended to simplify compliance for the firearm industry and ensure that more commercially available handguns over time become fully compliant with California's contemporary gun safety laws by requiring new semi-automatic pistol models to microstamp ammunition cartridge cases from a single location on the interior of the firearm, as opposed to from 2 locations.
Exactly what Justice Thomas said in the Bruin decision. Once they've overcome that hurdle, the burden then shifts to the state to show how the state's law is consistent with the nation's history, tradition of firearms regulations that existed at the time of the ratification in 1791.
Bruin voided New York's requirement that concealed carry permit applicants demonstrate proper cause or a special need for self-defense. The decision also struck down may issue permitting, which gave authorities the discretion to deny permits based on subjective criteria that go beyond basic requirements like a background check. Most significantly, Bruin rewrote the methodology. Lower courts defer to when evaluating the constitutionality of gun law, prescribing that it must have a well-established analog in American history. Specifically, the 77-year span from 1791, when the Second Amendment was ratified, to 1868, when the 14th Amendment was ratified. Within this framework, judges can no longer consider the real-world effects of gun regulations, like violence reduction. More than half a dozen states have reassessed their concealed carry, permitting laws in the wake of Bruin. Police and prosecutors have reevaluated their policies as well. On August 19, 2022, the New York City Police Department issued guidelines for concealed carry applicants to resubmit their applications if they had been denied because they couldn't demonstrate proper cause. These applicants must attest that they are familiar with state gun laws, submit a statement saying how the handgun will be secured, and describe how they have had training or plan to receive it. They have until October 18th to reapply. In the meantime, Attorney General Rob Bonta directed permitting agencies to stop requiring a demonstration of good cause in order to obtain a concealed carry permit, as it was now unconstitutional and unenforceable. He said they could still use other gauges of suitability like good moral character and suggested criteria for determining whether an applicant qualifies, including social media searches, character references, a history of racist behavior, financial stability, and honesty and trustworthiness. Bonta also said that permitting authorities can still ask why an applicant wants to carry a gun, even if the answer is no longer allowed to factor into their decision. The Second Amendment to the U.S. Constitution reads, "A well-regulated militia, being necessary to the security of a free state, the right of the people to keep and bear arms shall not be infringed." But the question is if this gun roster is still valid or not. California's Department of Justice is allowing a plethora of handguns certified for sale by licensed dealers to be no longer valid beginning in January 2022. Many of the 812 handguns listed on California's Department of Justice website as handguns certified for sale, including Beretta 92 FS, Browning 1911, and Glock 19. This means that many of the handguns that are legal for civilians to purchase from a federal firearms license dealer may not be legal to purchase moving forward. We are waiting to see what potential actions come from the California DOJ, if there will be a renewal for those guns set to expire, and how it will be enforced. As of now, there are no indications that the California DOJ is set to act on those guns that are set to expire. We will continue to monitor this issue and will provide updates as soon as they are available. This case perfectly captures the challenges of striking a compromise between upholding constitutional rights and reducing gun violence. The country is eagerly watching the legal dispute as it develops to see how the court's ruling may alter the outlines of gun control regulations, not only in California, but also nationwide. Remember to subscribe to the channel for more blues from the world of firearms. Click on the video links popping up for more interesting content, and we will catch you there in a minute.